Washington Journal continues.
And following the Justice Department's seizure of Associated Press phone records and the use of surveillance cameras in the wake of the Boston bombing, we now take a look at the intersection of surveillance and privacy with Cato Institute research fellow Julian Sanchez. And Mr. Sanchez, we're still learning details about this AP case, but take us through some of the legal issues that are involved here. Why was the Justice Department able to get the phone records of the AP?
Sure. So details are a bit slim. It sounds like in this case what they used was probably a grand jury subpoena. One reason they're able to do this relatively easily is that there's a 1979 Supreme Court case called Smith v. Maryland, in which it was held that the Fourth Amendment essentially does not apply to records held by third parties. In this particular case, Smith v. Maryland, that is, it actually dealt with the dialed digits of someone places when they're making a phone call, and they held there that a warrant was not necessary to get that, and so a mere subpoena is enough. And there's a variety of other tools that can be used. National security letters can be issued by FBI agents essentially without any kind of judicial oversight to get the phone records, essentially the itemized phone bill of when a call happens, for, between whom and for how long.
So is anybody questioning the legality of the seizure of records yet?
There is a question about whether it was a violation of internal Justice Department regulations. Federal regulations lay out a series of steps that are supposed to be taken when press in particular have their phone records seized. And the reason there is that if we look back to sort of American history, we see abuse of surveillance of journalists, among others, by Hoover and the FBI for many decades, and also because, of course, we understand that practices like this tend to chill the ability of the press to get anonymous sources, not just classified information, but anyone in government who might want to talk about embarrassing facts is going to be deterred if it becomes regular and routine for the government to obtain records like this so that no one has any kind of confidence that they can speak to reporters anonymously. This is certainly an administration that has prosecuted more people under the Espionage Act than all previous administrations combined. So I think there's what a lot of people have called a real sort of war on whistleblowers. We're already hearing from a lot of reporters saying they're having more trouble getting callbacks from sources. So there's a question of whether they followed all the steps there appropriately. The Attorney General is supposed to personally approve surveillance of the press. In this case, he had recused himself, although it looks like there wasn't any kind of formal memo recusing himself. He didn't file anything with a court to indicate that he had transferred that authority. But even beyond that, subpoenas of press records are supposed to be very narrow. They're supposed to, whenever possible, approach the press in advance and try and negotiate for the release of those records, because they can't delete the records the phone company has. So it's not like they're not going to be able to get the records if they talk to the press about it first. And in this case, it looks like they got a fairly long period of time, not necessarily 2 entire months, but several weeks probably, and from 20 phone lines, including the main fax and phone lines for the AP offices, and also an office at the Congressional Press Gallery. And so that's sweeping in an enormous amount of stuff that has nothing to do with a particular leak investigation at issue here.
Julian Sanchez writes about technology, privacy, civil liberty issues for the Cato Institute. In your opinion, as members of Congress look at this, what questions should they demand answers from the Justice Department going forward?
Well, so this is an ongoing investigation. We saw at a hearing on Wednesday that Attorney General Holder, above and beyond having recused himself from this particular case, didn't want to talk about an ongoing investigation. So it may be a while, frankly, before we can get any particular answers about this case. Certainly what we should want to know is, one, whether any other records were obtained, that is to say, not just phone records. The federal regulations governing this and requiring eventual notice really specifically talk about subpoenas for telephone toll records. We should ask, well, they went very broadly with phone records. Did they try and get other kinds of records, internet records, web browsing? Journalists today, as I'm sure you know, do a lot of their interactions through internet communications, not just making phone calls. Maybe more importantly, I think we ought to be looking back, precisely because those federal regulations are so narrow. The FBI's own internal manual that was obtained through a Freedom of Information Act request explicitly says, when we say subpoenas, we really are just talking about subpoenas, not national security letters, not various other Patriot Act authorities that may enable people to obtain records. And we know from past audits by the Inspector General that there have been cases where very large swaths of time of records about reporters' activities were obtained, and in some cases uploaded into databases where no one was told about it for 3 years. We should want to know whether this is as sort of bizarre and unprecedented a case as most people seem to believe, or whether in fact this is more common than we've been led to believe, and we simply haven't heard about it.
Julian Sanchez works with the Cato Institute. We'll be taking your calls and comments on this subject of privacy and surveillance. Phone lines are open now. We'll show you the numbers on screen. But while we're doing that, Julian Sanchez, explain what the Cato Institute is.
Sure. The Cato Institute is a nonpartisan libertarian think tank in Washington, D.C. We've been around for 30 some odd years and cover a whole range of public policy issues. I focus on technology, privacy, and civil liberties. But we sort of cover the gamut.
Talk about what Congress, the questions that Congress needs to ask. Talk about what the president has already done since this AP story broke. The idea of supporting a reporter shield law. What is that, and why is it significant that he's now supporting it?
Right. I mean, it seems like actually the president had, I think, in the past supported a similar law. This one, it's not clear whether this one, the one he's proposing in its details, and need to look more closely at it, would actually have prevented the seizure of AP records in this particular case. It's, again, perhaps not a bad idea to codify in federal statute as opposed to mere internal regulations that there is an obligation to take special care because of the First Amendment interests implicated when press records are seized. I think it would be a better move, however, as Justice Sotomayor suggested in a recent Supreme Court opinion, to really re-examine more broadly the idea that third-party records that can be quite detailed and reveal a lot about who we're communicating with, either by phone or online, what websites we're reading, really should be so easily available. You know, the line between press and ordinary people these days is a lot fuzzier than it used to be. It used to be, well, a reporter was someone who worked for the AP or some other news organization. A reporter now can be someone with a blog that they write on part-time, or even someone who tweets about information part-time. So I think a better move would be to look at the status of everyone's records, and I think Jared Polis and maybe Justin Amash have introduced legislation that more broadly does that, is to say, at least some kind of court order, something issued by a judge, not a prosecutor or a government agency acting on their own sort of recognizance, should be necessary to get detailed phone records. For
anybody, not just reporters.
That's right.
I want to show you a clip of Eric Holder on Wednesday at a Judiciary Committee hearing talking about this issue and the balance that needs to be struck where citizens' rights are protected versus law enforcement doing their job.
Yeah, absolutely. I think we have become more and more an information society, and we still have and should have expectations of privacy, however it is that we communicate. At the same time, I want to make sure that law enforcement, in the way that it did 40, 50 years ago, has the ability to acquire information, and how we strike that balance I think is really important, and is really one of the most important conversations I think that we can have in the 21st century, and one that I think that this administration would like to engage with Congress on, so that we come up with a set of rules that probably not perfect, but will meet somewhere in the middle, so that we have that we can maintain privacy while at the same time maintaining that ability that law enforcement has to have.
That was Eric Holder at a Judiciary Committee hearing on Wednesday. We're talking with Julian Sanchez of the Cato Institute about these privacy versus surveillance issues. I want to bring in from Phoenix, Arizona on our Republican line, Daniel, with a thought on this issue. Daniel, you're on with Julian Sanchez.
Yes, I have two comments. First of all, I want to know if the guest thinks that we actually have a right to privacy since it's not mentioned in the Constitution. And number two, I want to ask the guest what he thought about the last guest pretending to be a journalist, which was obviously a Democratic Party operative. Oh.
Well, Julian Sanchez, let's focus on the privacy issues and
So I didn't
surveillance.
actually see the last guest, and I know a lot of people who are journalists and have strong opinions on the right or left. They're not necessarily mutually exclusive. I can't speak to this particular guest. As it concerns the right to privacy, so privacy is sort of a nebulous concept. I think what is crucial for this particular kind of case is that what we unambiguously have, and what is unambiguously laid out in the Constitution, is a right to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures. And it's very clear if you look back to the writing from the founding era about the controversy over general warrants and writs of assistance, that this was, in a way, one of the key reasons, one of the key sparks that set off the American Revolution, and that the idea that we should enjoy a certain sanctity in our homes, but also in our writings, and that a government that was able, without restriction, to obtain access to information about our private papers was one that would stifle dissent. The cases that most incensed the colonists from the British experience, involving essentially King's messengers ransacking the homes of dissident publishers, the authors of a pamphlet called The North Briton. They saw that privacy in this sense of freedom from unreasonable search was really crucially linked to the ability to have an effective check on government abuse and government power. And so that's certainly, I think, a right that is clearly in the Constitution, and that we should recognize was correctly identified as absolutely essential to a functioning democracy.
Let's go to Sarah now on our Democratic line from Ambrose, Georgia. Good morning, Sarah. You're on with Julian Sanchez.
Yes, I have a statement, and that is that I think we should put things in priority. The things that we're discussing right now are important and should be discussed, but they should not be put in front of and causing us to Congress to put aside the bills that have to do with this protection of this country, of guns and our children being hurt in these schools, passing a jobs bill so that we can get back to work, and number 3, getting an immigration law going so that we can get people registered, and therefore they can become ways and means for them to become citizens. These things, yes, Benghazi is important. How many people did we lose there? How many people have we lost in those schools? There's 20 young people who never.
Well, sir, we're talking about privacy issues and surveillance, and there have been some bills that have been moving or have been put forward since the AP story broke, specifically the Cyber Intelligence Sharing and Protection Act. Mm-hmm. Can you explain that for viewers?
The CISPA actually predates all of this. I mean, this is a bill that was in previous session considered and then has been back for a while and seems to be, for the moment, sort of dead again. It passed the House by a substantial margin, but seems to be sort of quiescent in the Senate right now. The idea behind CISPA is to enable greater information sharing between private parties and the government for the purpose of essentially improving cybersecurity by having a kind of advanced warning system as cyber attacks are ramping up. The idea now is that federal privacy laws create limits of some kind on the way, not necessarily the victims of a cyber attack. The victims of a cyber attack can always share sort of their logs with the government, but what they would like to be able to do is have AT&T and Verizon and the carriers, the big Comcast, the internet service providers, kind of share information that they're seeing to provide a kind of 30,000-foot bird's eye view on the situation. So as a botnet is ramping up to attack certain pieces of critical infrastructure, the government can have advance warning of that, know what kind of malware is being used, what kind of patterns of attack we're seeing. And I don't think anyone objects in principle to that. The problem is that because they didn't want to write it narrowly to talk about particular kinds of information they were going to be able to share, internet protocol headers and net flow logs, things that are maybe obsolete in 5 or 10 years, it created this very, very broad kind of immunity from liability for information sharing, meaning not just all federal and state privacy laws sort of had a big loophole in them, but even private contracts. So if you had a privacy policy that says we promise not to share various kinds of information with anyone, including the government, that would also essentially be nullified. And there wasn't really a specification of exactly what the information was. It was cyber threat indicators or who it could be shared with. This was, I think, a reasonable fear that you created this setup for just enormous quantities of information of unknown type to be funneled to some government agency, including the NSA, other spy agencies, and that kind of database would sort of inevitably be tempting to begin repurposing for uses other than cybersecurity, even if the law said, technically that's all that it's for. I think this is something that can be, when we talk about the balance between privacy and security, sometimes we act like it's a zero-sum game, as though more security necessarily means less privacy. This is a case where the kind of information they need for cybersecurity is mostly not sensitive or private information, and there's just been a kind of unwillingness to get into the weeds a little bit and try and craft this so they can share the information they need without sort of opening up the door and saying, yeah, potentially you can share people's email contents if that's a cybersecurity threat indicator.
Let's go to Steve now from Osage Beach, Missouri on our independent line. Good morning, Steve.
Good morning. Thank you for the time. I know my protections against we the people. So my true question is what kind of protections do I have against a private sector think tank like this gentleman's involved in?
Steve, what do you mean by protections?
I don't do any wiretaps. I mean, have any particular ability to read your email. So,
Steve, if you want to,
you have the protection of tort law, I suppose. If I hacked your email, you could sue me under the Computer Fraud and Abuse Act, but I wouldn't do that.
Steve, if you want to read more about Cato's work, it's cato.org, and you can follow Cato on Twitter at Cato Institute, CATOINSTITUTE. We're talking with Julian Sanchez, who writes for the Cato Institute. He's a research fellow there. We'll go now to Jack from London, England. Jack, thanks for calling in from overseas. Your thoughts?
Hello, very good to speak to you. How are you doing? Hello, America.
Go ahead.
I wanted to say a few things. First of all, I support the Cato Institute and in its support for freedom, principles of freedom, but there's an issue in America. The 16th Amendment apparently is not constitutional. Apparently, that would mean all the taxes you've paid up to now are illegal. It's probably as constitutional as your Federal Reserve, which is also not an agency of the government, but is a private bank owned by families around the world. This is a long issue. But
well, Jack, let's return to surveillance and privacy issues. Your thoughts on that for Julian Sanchez, who's our expert talking about that today.
Well, things unfortunately are getting worse. Apparently Google can spy on all people's emails and all the content, which is supposed to be private, and I don't think it will be better in the future. I support what the Cato Institute is actually advocating in principles of freedom and sort of free markets and everything, but I don't think that the situation is going to be better in the future where privacy is concerned. I think America is turning into a police state, which is not a good thing.
Well, Julian Sanchez, the caller brings up Google. Here's a story from the Hill newspaper talking about lawmakers fear privacy risks from Google Glass, which is in development. Can you talk a little bit about that?
Sure. Well, so in a way, I think this is a little bit strange. I mean, Google Glass is essentially a way of stapling a smartphone to your head. So on the one hand, in terms of the actual technological capacity, it's not really any greater a threat to privacy than the phone that's already in your pocket. It's a small device with a camera that's internet connected, and so certainly you can infringe on people's privacy by taking photographs in situations where they might not want you to. It may make indeed a difference that it's something that's actually on your head. I mean, I sort of said that facetiously, but the fact that the camera there is always sort of pointed, aligned with your eyes, may mean that it is more easy to just kind of constantly be recording, catch more sort of potentially not necessarily totally private or intimate, but moments that people don't expect to be broadcast to the world, in a small party setting, for example, and deal with the consequences of that. But I think that is mostly going to be the sort of thing we're going to have to resolve not through a legal approach, but through norms. We're going to need to develop sort of rules and understandings in the same way we have with cameras about, when it's polite to take someone's photograph. We'll probably need norms about whether you need to take off your Google Glass when you walk into a bar or a private party. And that's going to be probably awkward for the first few years, and we'll, I imagine, sort of settle it out as that technology becomes more common.
And Congress's bipartisan privacy caucus is on this issue, according to that Hill story, sending a letter to Google asking for more information about the development. Some of the members who signed the letter to Google from the bipartisan privacy caucus: Joe Barton, Republican of Texas; John Barrow, Democrat of Georgia; Steve Shabbat, a Republican from Ohio; Hank Johnson, Democrat of Georgia; Walter Jones, Republican, North Carolina; Rich Nugent, Republican of Florida; Bobby Rush, a Democrat from Illinois; and Loretta Sanchez, a Democrat from California. That's all members of Congress's bipartisan privacy caucus. I want to go now to Boston, Massachusetts. On our independent line, Jerry is waiting. Good morning, Jerry.
Good morning. Thank you for C-SPAN. I just wanted to come back to the AP story, which, as I understand it, the government had a mole that was close to the bomb maker in Yemen, and AP disclosed that, which kind of thwarted our ability to capture and thwart possible additional bomb attacks. Let's just assume, for the sake of discussion, that this guy was building a nuclear thing that he could bring into the United States. What is the responsibility of the press to kind of withhold that information? As I understand it, the government asked the AP not to disclose it, yet it was disclosed, which thwarted our ability to get at this bomb maker. Assume it was a nuclear bomb, just for the sake of discussion, and it was going to be brought into the United States. Where's the balance of interest where we want to get at, number one, the person in the government that disclosed this to the press, and how aggressive we want the government to be in trying to find out who that person was, which might have prevented or thwarted a possible nuclear attack on the U.S.?
So a couple things. I mean, one, I guess I'm happy to discuss hypotheticals, but we should step back and recognize that sort of bumping this up to a nuclear threat kind of brings in a whole bunch of other considerations that are not necessarily realistic. I mean, the idea that Al-Qaeda would have a nuclear device and then be realistically able to transport it into the United States is I mean, getting not quite science fiction level, but far, far from anything realistic that we've actually seen in the world. Second, it's not actually certain at this point that the source for the story was from within the United States government. The Saudis, were involved in this, knew about this, may have been talking about it. I have no idea what the source for the particular information you're concerned about is. Third, it's not clear to me that this story actually in some way thwarted our ability to do further counterterrorism. That may be the case. We'll presumably discover that as this moves forward. But we've seen, I think, quite a lot of cases in which people have been indicted for sharing information that supposedly risked national security, proved in fact to just be embarrassing to the government. Thomas Drake is a case like this. Eventually, his case against him effectively had to be dropped or at least reduced to effectively a misdemeanor of sort of inappropriately using government computers because he had shared embarrassing information about waste within the NSA, not dangerous information. But in this particular case, my understanding is that the AP had, in fact, waited on this story. They did hold it and moved forward with publication only when they had been convinced through their dialogue with the intelligence community that there was no national security risk from publication. The White House, the administration, was planning to essentially announce the foiling of this plot within a few days, and I guess wanted a few more days so they could be the ones to announce it. But it's not, let's say, it remains certainly a serious question whether there was any kind of real national security implication in this case. I think certainly if we're talking about a case with a nuclear device, I cannot imagine a journalistic organization that would that would not hold on to that and think about it very seriously. Remember the warrantless wiretap story that the New York Times broke was one they sat on for nearly a year at the Bush administration's request.
Well, the last caller was from Boston, Massachusetts. A lot of discussion coming off the Boston bombing about the use of surveillance cameras in the aftermath there. As we look at lessons learned, do you think surveillance cameras could have helped prevent what happened there?
Probably not, no. I mean, so we're seeing actually a lot of calls for more surveillance cameras as a result of this. And certainly surveillance cameras can be useful in solving crimes after the fact. They may even help to deter, they're not necessarily prevent, ordinary crimes, although the literature on that is very mixed. If you look at the research coming out of the UK, you don't really see a significant effect on crime reduction there. You've seen studies in the US where you see in some cities, in some neighborhoods that have cameras, you see an effect on ordinary crime. In other areas, you see no real effect at all. But there's a difference between deterring ordinary crime and catching criminals and preventing attacks. And we've really not seen any evidence that surveillance cameras are good at that. Partly because terrorism is just incredibly rare. I mean, it's always makes headlines when it happens. It's very scary, but it is something that happens pretty infrequently. The dozens of attacks every year that everyone seemed to be certain we were looking at after 9/11 just never materialized. And the form terrorism takes is so sort of variable that there is I think an understandable fantasy, a kind of wishful thinking that somehow if we get just the right algorithms and the right clever camera that will detect some kind of shady behavior patterns, we'll be able to stop this stuff as it happens. But terrorism can look like a guy dropping a backpack in a trash can or 100 other things. And the problem is you can't send the SWAT team every time someone drops a backpack in a trash can. And so there's just not much reason to think you're going to be able to prevent terror attacks as opposed to being able to perhaps identify perpetrators after the fact. In the case of Boston, though, it wasn't a public citywide network that was so useful in identifying the perpetrators. It was the camera outside a Lord & Taylor department store. There's just tons of private cameras out there as well. I think 30 million more cameras, only a few really government operated since 9/11 have been installed. They're cheaper and more resilient, and it's easier to store more data with them. And so we may be able to get a lot of the after-the-fact benefits of surveillance cameras without spending hundreds of millions of dollars on public citywide networks, just because so many private businesses are already installing their own, and there's a sort of added civil liberties benefit there. Those cameras aren't networked, so you can, after the fact, of course, go and get the evidence you need to solve a crime, but you haven't created a kind of citywide panoptic surveillance system that can be used to track someone over months or years.
And you describe it in your piece on the Cato Institute website that you can go read The False Security of Surveillance Cameras as the idea of little brother versus having a big brother watching.
That's right. I mean, and that model was used here in a lot of ways. We see that actually all this time. Recently, there was a case where they released a photograph of a child pornographer on the internet and basically said, "Someone identify this person to us, please." And they got calls in. Now that can be problematic. I mean, there's those if you see something, say something. Marquees on a lot of subway systems, and they say, last year 10,000 people saw something and said something, and they never tell you how many of those were something. And it seems like you get a lot of sort of false reports that way. But by distributing the sort of surveillance power that you're using to apprehend people in cases like this, you, I think, avoid a lot of the concerns people have about centralizing power, about creating a set of eyes that looks one way. They're watching us, we're not able to watch back. A little brother model says, people will help with the kind of surveillance technology we all carry around with us in a case that people recognize as important without giving a centralized authority to power to spy on us in ways that we don't fully understand.
Let's go back to the phones. Daryl is waiting from Detroit, Michigan on our Democratic line. Good morning, Daryl.
Good morning, sir.
Go ahead.
Thank you for CPS. C-SPAN, I'm sorry. I'd like to say that the way this country is trudging along on surveillance, by the year 2034, I think we'll reach 1984. People don't realize that for every surveillance operation that comes to sunlight, there's probably 15 or 20 that do not. Right now, we got Utah NSA building in progress. It's 240 acres, 24 acres of computer hardware alone. It can monitor just virtually every phone call in the world on any given day. I want to know, I'll take my answer offline. I want to know what protections the American citizen has against domestic surveillance on them by this, for example, NSA computer in Utah. Thank you.
Mr. Sanchez.
You know, I think he highlights an important point here, which is, especially as technology changes, the problem of not being really able to gauge the total scope of surveillance. Now, some of that is just a function of national security powers. So surveillance under the Foreign Intelligence Surveillance Act, or FISA, and various kinds of Patriot Act related surveillance powers are just covert by design. So we'll never find out about that, which creates a kind of terrible catch-22. There was a recent Supreme Court case called Clapper v. Amnesty International. It was an attempt to challenge sort of large-scale programmatic wiretapping by the NSA. Journalists and lawyers and activists who had regular communication with sources or clients overseas who said this sort of expanded wiretapability affects our ability to communicate with our clients and sources, and we believe that it violates the Fourth Amendment. And the Supreme Court said, well, you can't prove, even if you think it's very, very likely, even if there's some reason to think it's very likely, you can't prove that you have actually been wiretapped yet, even though they're doing this on a very large scale. And so you don't actually have any standing to bring this challenge. And of course, the problem is that under the law, perhaps appropriately, they never have to tell anyone that they've been wiretapped. It's just permanently secret. There may be good reasons for that, but it does create a situation where effectively that type of surveillance is, or at least the law authorizing that type of surveillance, is effectively immunized from constitutional challenge, which I think is a problem. But even in the criminal context, that is not national security, not foreign intelligence, but ordinary law enforcement, technological change has sort of opened up a gap between what is happening and what we are aware of happening. Every year, the U.S. courts have to put out a report on wiretaps, traditional phone wiretaps, and that reveals a fair amount of information. What kind of crimes are they investigating? It turns out it's overwhelmingly drug cases and not murders and kidnappings. How much does it cost? How many convictions come out of it? How many people are affected? And that's useful information, but it's not information we have about, for example, surveillance of stored emails, surveillance of phone records of the kind involved in this AP case, surveillance of location using cell phones, which has become apparently a huge growth industry. I've seen estimates that there are at least 30,000, probably a lot more, sort of secret electronic surveillance orders just on the criminal side, not any of this national security stuff, every year. The major phone carriers have reported that in answer to Congress, getting about 1.3 million requests of various kinds for data from government every year at all levels. And a lot of that is location tracking. And yeah, part of the problem is that unlike the little brother model, we just have no sense of how often this is happening, how many people are affected, what happens to that data.
Let's go to Tracy now from Muncie, Indiana, on our independent line. Good morning, Tracy.
Good morning. I wanted to ask Julian if he wanted to speak to the routine surveillance of financial transactions by Bank Secrecy Act officers like myself all over this country.
So I'll admit this is not something I am as familiar with, but certainly this is an area that is, I guess, maybe just because it's not as sexy to a lot of people as communication surveillance, perhaps not gotten enough attention. I know that when you compare something like, let's say, national security letters used by the tens of thousands every year.
These were the national security letters that were authorized way back to the Patriot Act?
Yeah, they actually have existed since the 1980s, but they used to be very limited. It used to be that you really could get a very limited set of records about someone that you had evidence was in fact an agent of a foreign power, was a member of a terror group. The Patriot Act essentially expanded the kinds of information you could get and the entities from which you could get it, and at the same time removed that restriction. So it was no longer just, you can get the records of someone you have evidence is a terrorist. It was, you can get records from anyone, essentially, that are relevant to an investigation, and that's essentially a nothing standard, which means they're not totally frivolous or useless to something you're trying to do. So yeah, I think last year it was 6,000, but in 2010 it was something like 14,000 Americans who had records seized under those powers, and that does not count actually requests for basic subscriber information, meaning these are IP addresses, we want to know the name that is associated with that. We want to sort of de-anonymize anonymous online activity. So not counting those, only counting records for more detailed financial and communications data. We're talking about thousands, if not tens of thousands of Americans every year. But the bank information, so banking information, of course, can be obtained using national security letters, but there's also these suspicious activity reports that banks are required to file, and the numbers there are, I believe, even more substantial. So there's a huge kind of invasion of financial privacy that doesn't even require the government to proactively look at anything. They're just getting these sort of feeds of data from the banks themselves.
Let's go to Tom now from Stewartsville, New Jersey, on our Republican line. Tom, you're on with Julian Sanchez.
How are you?
Good, go ahead.
Good. The question is this, it's regarding the AP. When they went in, they subpoenaed these records from AP. The question I have is this. If it was such a big secret as far as what was happening and so on and so forth, and that's the reason they're using for going for these subpoenas, why didn't they subpoena first, since it should have been a small group that would have known about this incident? Why wouldn't they subpoena all the phone records of the people that were given the information through the White House, and then gone after and checked the numbers that way? Why go after and send a big net out there for all the people that potentially use those phones and personal email records and so on and so forth? That's the disgraceful part of this. There was no reason to do it. It should have been done with the people that they knew had the information. That's where the smallest imprint would have been.
So this is sort of the inside-out versus the outside-in approach?
Well, so the government is claiming they did that first. They say they did hundreds of interviews within the government with cleared personnel and people who had contact with them within the government. They did look at phone records for people who work for the government. I mean, if you have a clearance, you usually have to sort of sign something that essentially says, I understand that you can look at my phone records and I will, turn those over when necessary or appropriate. And apparently they didn't find anything, but that does raise the question: why would they then think, if they didn't have records from these people showing their contact with the AP from their own phone records, it's not clear what they thought they were going to find in the AP phone records. I mean, if it's just a question of someone using a payphone or a burner cell phone or something for their communications with the press, or for some other reason, their own records were not showing activity that allowed them to narrow it down to a small number of suspects. I'm not sure what they thought they were going to find in the AP records. It's also, of course, possible that they had their conversations over Skype instead of the phone. So it certainly remains to be seen whether indeed they're going to have gotten anything useful from these records that they've subpoenaed, which that would be, I think, the worst shame. It's clear from what reporters are saying already that this action has had a serious chilling effect on reporters and their ability to talk to sources. It's not clear yet that this is actually going to help them resolve the case. We'll see. It would be certainly a shame if they had done this for no real benefit.
Andy's up next from Columbia, South Carolina, on our independent line. Andy, you're on with the Cato Institute's Julian Sanchez.
Yeah, hi guys. Enjoy the show as always. I'm really don't understand what the whole hoopla is about this Associated Press thing. I understand the issue, the rights to privacy and everything else, but in the kind of technological world we live in, sometimes that's just not possible. It has to be a certain balancing act. And once again, I see a situation where the Justice Department is trying to keep us safe the best way they can, the FBI, the CIA, and all these guys, and we have to trust that their intentions are honorable. And then here come the Republicans, which is one of the reasons why I don't know if I'm ever going to vote for him because they're just not credible. There was a whole lot of much worse transgressions done during the Bush administration, and no one took them to task like this, not even the Democrats. And here we go, and you've got all these politicians running around trying to link the White House to this and talking about impeachment, this and that, and what is the big deal here?
Julian Sanchez.
Well, I mean, the big deal, I think, is that Thomas Jefferson famously said that if you had to choose between having a country with newspapers but no government, or a government without newspapers, unchecked by newspapers, he knows he would, without hesitation, have chosen no government but newspapers. And I think that may be a little extreme, but we understand that a fundamental part of our democratic system is the ability of the press to check government abuses, and that in some sense, it's not a formal branch of government, but they call it the fourth estate, that is in some sense an essential, though independent, part of a functioning democracy, and that if you break that function by making it difficult for press to talk to government sources or any source who needs anonymity to be able to speak, that you have removed an essential feature, as essential as oversight by the courts in some sense, that makes our system function. And our Constitution is just not based on the premise that we need to trust their intentions. In a way, the entire Bill of Rights is a long document explaining the ways in which we're not going to trust the government's intentions, but rather limit their power because even if the intentions are good, it is too easy to undermine the sort of prerequisites for a functioning democratic system.
We've been talking with Julian Sanchez. He's a research fellow at the Cato Institute. You can check out his work at cato.org. Thanks for coming on today.